Hello friends, I hope you are safe at your home and at your nearby places. Now starting with the concept of merger and amalgamation that we have left in the last session immediately before the declaration of holiday. We have already discussed the basic topics on a merger and amalgamation. That includes the scope of merger, scope of amalgamation, and why company prefers merger and amalgamation. We have in depth discussed the concept of takeover, and I have already discussed the meaning of takeover and the meaning of merger and amalgamation and how merger differs from amalgamation. Now coming back to the main point, that is merger and amalgamation, we are now starting the legal framework of merger and amalgamation. Now, as I already discussed a few days before, that is immediately before declaration of holidays, that the merger and amalgamation is the topic that not only governs by the Companies Act, but it also governs by other legislative provisions, including provisions of Competition Act 2002, provisions of Indian Stamp Act and the respective Stamp Act of the respective state. Apart from this, it also affected by the provisions of Income Tax Act and so on. Now in today's session, we are focusing on the legal framework of the merger and amalgamation given under Companies Act 2013. Companies Act 2013 contains 5 major sections that deals with the merger and amalgamation. It starts with section 230 and ends on section 234. Section 230 of the Companies Act 2013 deals with the internal scheme of reconstruction. Now, internal scheme of reconstruction differs from merger and amalgamation. I'll discuss in detail later on, but for time being, section 230 of the Companies Act deals with the internal reconstruction. Section 231 of the Companies Act 2013 deals with power of NCLT to issue various kinds of order. Section 232 deals with the merger and amalgamation, and that is what we are supposed to discuss in detail in upcoming sessions. Section 232 is the basic provisions that deals with the merger and amalgamation, and it laid down the detailed procedure to be followed by every company proposing the merger and amalgamation. Section 233 deals with the fast track merger, that is the merger of wholly owned subsidiary with its parent company, and fast track merger proposed for small companies. Section 234 deals with the cross-border merger and amalgamation, that is the situation where one Indian company and one foreign company proposes merger and amalgamation. That is, section 230 to 234 are the basic section that governs the legal issues relating to the merger and amalgamation. Yes, we have section 235 also. Section 235 is more about the takeover of unlisted company. We have already discussed in detail the takeover of listed company under SEBI takeover regulation 2011. In detail, we have discussed what is person acting in concert and when the acquirer is required to give open offer and etc. We have already concluded the topics SEBI takeover code. Now we are starting section 230. In today's session, I'll give you the overall idea about merger and amalgamation and its legal framework. Section 230 deals with the internal reconstruction. Here, I would like to highlight that internal reconstruction is not the merger and amalgamation. Internal reconstruction is the scheme of internal reconstruction proposed by company with its member or with its creditor. When company feels that the present balance sheet not reflects true and fair view of the exit position of the company, and there is a need to reconstruct the entire structure, there are few assets shown in the balance sheet not at its market value, meaning thereby the book value may be 10 crore rupee. However, at present the market value may be 1 lakh rupee. So the book value nowhere presents the true position. Moreover, company is of the opinion that some of the debt need to be restructured instead of paying debt in cash company proposes to issue equity shares. So there are many types of reconstruction that can be proposed by the company. Now, if a company wants to propose internal reconstruction, then it can use section 231. 230. 230 is the detailed provisions that deals with the internal reconstruction. Here, company gives plan for internal reconstruction. It proposes the plan to its creditor, to its member. If the required majority of the creditor as well as of the member approves the plan will be given effect. The procedure to be applied for section 230 is the same as that of section 232. So as such, as far as procedural aspect is concerned, there exists no difference. Companies require, whether it is merger and amalgamation or internal reconstruction, company is required to follow the same procedure.